Okay, so let's go ahead and put together an asset protection plan for a high net worth individual. I'm the business guy. I'm the CEO of Asset Protection Planners, the nation's largest asset protection firm, and I've been in the business for 33 years. So this particular individual has $5 million in a stock market portfolio, 4 duplexes, all free and clear, worth $1 million each, and a personal residence worth $3 million. So what do we do for this particular individual? First of all, we want to know what kind of risk they have, what kind of person or company they have coming after them. In other words, how aggressive that litigant is going to be. So let's go ahead and take a look and see what we would do for a typical individual in this situation. So the basis of an asset protection plan for a high net worth individual is typically going to include an asset protection trust. And the strongest asset protection trusts are international. Of all the different choices, the Cook Islands Trust, the Belize Trust, the Nevis Trust, the strongest asset protection trust in the world in our experience, with the longest case law history. Now, this country is part of New Zealand, so it's the most trusted jurisdiction in the world, is the Cook Islands. So the Cook Islands Trust is going to be the basis of our asset protection structure here. So we set up a Cook Islands Trust represented by this rectangle here. Our Cook Islands trustee law firm can step in to protect you as needed. And so what we're going to do, so you have the initial control of everything, is we establish an LLC, a limited liability company. We establish that in the Cook Islands, and that will hold your bank account. So you're the manager of the LLC, you're the signature on the bank account initially, and when the bad thing happens, you have a licensed, bonded law firm / trustee that can step in to protect you. Why do we do that? What benefit does that provide you? Here's the answer. This trustee law firm is not subject to U.S. court orders. I've been setting up Cook Islands Trust for about 30 years. Our team has set up more Cook Islands Trust than anyone in the world. Can you trust the trustee? Well, first of all, it's not just one guy, it's an entire law firm. And second, since this is such a huge contributor to the GDP, these trustees are very highly vetted before they're allowed to get a trustee license. And they're also the most highly regulated trustees in the world. So the regulators go into their offices on a regular basis to make sure that they're taking care of the clients properly. So they're very vetted. I have a Cook Islands Trust myself. The trustee company, they're the only signatory on the bank account. Very honest, trustworthy trustee culture. And the Cook Islands Trust are the most respected, well-trusted trustees and trusts in the world. So inside your LLC, you're going to put your bank account. You're going to put your stock market portfolio. You'll put all of your liquid assets in the limited liability company that's inside of the trust. Again, you're the signature on the bank account. You're the signature on the stock market portfolio. Unless in the future, you need the trustee law firm to step in. Because if you remained in that position after you had legal duress or a judgment, the judge could just force you to turn all the money over. We have clients saying, well, I want control. Well, you having control means you having no control because the judge now controls you and they can make you do anything they want. So that's why we need a third-party intermediary, a trustee law firm that's been licensed and bonded and vetted that can step in to protect you as needed. So this is what we're doing for Joe, that high net worth individual's liquid assets. Now, Joe also has a personal residence and Joe has the investment property. So what do you do for them? For the personal residence, we put it into a land trust for privacy of ownership. So our company drafts land trusts. We also draft the deed that's recorded in the public records. The benefit there is privacy of ownership. The public records reflect that the house is in the land trust, but it doesn't say who is the beneficiary of that land trust, so it keeps your name out of the public records. And typically what we'll do here is we'll have a trustee of the land trust, which is a Wyoming LLC, which you own. So that way you have control of the trustee, but your name does not appear in the public records. And what we'll do here is we will typically have a nominee manager to keep your name out of the public records. And we have a virtual office associated with this Wyoming LLC that serves as the trustee of your land trust. Because what shows up in the public records? Well, the address of the property. Well, you can drive by and see that, so there's no secret. The name of the trust, for example, the 123 Main Street Land Trust, and the name of the trustee. Those 3 things appear in the public records. So we have the land trust set up so nothing ties back to you. We can also have a living trust involved, so the living trust can be the beneficiary of the land trust. That way, when you die or you and your spouse die, everything goes to the kids or whoever you want to have inherit your money. We then take an LLC and we record an equity stripping line of credit type of mortgage against your property. So line of credit meaning no money is changing hands. Like if you got a line of credit down at Bank of America, you can record that against your home, but unless you write a check and draw the money out of the line of credit, it just shows up in the public records as an encumbrance against the property, but no money is changing hands. So this is initially payable to, what we'll typically do is that LLC that's inside of your offshore trust will initially record a mortgage against your property. And again, that is an equity line of credit, so there's no money changing hands. Now, we'll get to this in a bit. If we need to get a third-party lender, we have third-party lenders in the Cook Islands who can buy this mortgage and put the proceeds in a you can't touch it account in your offshore trust. So we have that covered if we need to get to that next stage. Okay, now let's talk about the investment property. What do we do there? We'll go ahead and take a look at one investment property, and then we'll look at the broad picture and look at all of them in a little bit. So here's that duplex that's worth $1 million. It's free and clear. We put each duplex in separate land trusts. We do that even if they have a mortgage on them. If you put a property into a land trust, it does not invoke the due on sale clause because we leave you as the beneficiary of that land trust. And then later we have a separate piece of paper called an assignment beneficial interest. And we assign that beneficial interest in the land trust over here to an LLC because it is the beneficiary of a land trust that absorbs all the liability. So we make an LLC the beneficiary of the land trust. So you have asset protection and lawsuit protection. So you have the property is owned by a land trust, and we make the LLC the beneficiary of that land trust. So you say, business guy, why not just put the property straight into the land trust? Well, two reasons. One, you have an extra layer of privacy. And number two, when you put the property into an LLC, there is a good possibility that lender can call the loan due, called the due on sale clause. Now, Fannie Mae and Freddie Mac regulations may allow you to put it directly into an LLC, but what if you don't have a Fannie Mae or Freddie Mac loan? They can call the loan due and take the property away if you don't pay it off 100%. So that's another reason that we use a land trust. Layer of privacy and prevents the due on sale clause. What we do again, the same thing, we take the LLC, typically the LLC that's inside of your offshore trust, or we may do a Wyoming LLC with the nominee service and the virtual office service so it's not associated with you. And again, we record an equity line of credit type of mortgage, so no money changing hands initially, against the property. So in the public records, it looks like it's mortgaged to the hilt. So we have the land trust for privacy of ownership, the LLC for asset protection and lawsuit protection, and then we have the equity stripping line of credit mortgage against the property to strip out the equity and make you look not very attractive to sue. Let's go ahead and look at the big picture here, talking about the real estate. Each piece of property is in a separate land trust. You see here, everyone is in a separate land trust. Your personal residence in a land trust. And each property that's an investment property has an LLC as the beneficiary of that land trust. So why don't we use an LLC for your home? The reason is because it could kill a lot of the homeownership tax benefits. Homeownership tax benefits are in a separate bucket than investment property tax benefits. We don't want you to lose the ability to write off your interest. We don't want you to lose the ability to sell the property and not have to pay taxes on the first $250,000 for a single person or $500,000 for a married couple. You would lose that if you put it into an LLC. So that's why we put it into a land trust, so you can retain all those benefits. From the IRS's perspective, a land trust is non-existent for tax purposes. So all the tax benefits you get for homeownership remain when the property is in a land trust. And like we showed before, we take this LLC, typically this is the LLC inside of your international trust, and we record equity stripping mortgages against each property. So all the properties look mortgaged to the hilt. So again, here's another way of illustrating it. Your offshore trust owns an offshore LLC that holds your bank account and investment accounts. Okay, you with me? And this offshore LLC will record equity stripping mortgages against your properties and other assets that you own. We'll use a mortgage if it's a piece of property, and we'll use a UCC-1 form to record against personal property or business assets or stock that you own that's not publicly traded to strip the equity out of those assets. And then if needed, we have a third-party lender who can purchase all those liens and put the proceeds in a you can't touch it account in your offshore trust. Now, that won't be money you can run away with and spend, but you couldn't spend it anyway. It's just dead equity. So you can't run off and spend it because that would be too risky to the lender. You and your spouse are beneficiaries. When you die, your kids become beneficiaries. And our licensed bonded trustee company law firm stands in as a barrier between you and the courts to protect your assets. So in other words, the U.S. courts say, give me the money. Our law firm in the Cook Islands says, no, not going to. You don't have jurisdiction here. You don't get held in contempt because it is not you refusing to comply with the order. It's somebody that's not refusing to comply with the order because they don't have to. Courts don't have jurisdiction over foreign law firms. So therefore, they stand between you and that judgment to protect your assets from the lawsuits, and you're legally bulletproof. So what we've essentially done is we've protected a $5 million stock market portfolio. We've protected a $3 million personal residence, and we protect $4 million worth of investment properties. So we've essentially protected $12 million in assets. We just had a client that had about $30 million in real estate that we just protected. So that is an asset protection strategy that we employ for a high net worth individual. If you appreciate this information, please click like below. That helps me out a lot. And subscribe because I'd like to see you again. Thanks for watching. This is The Business Guy.